This case right here is a perfect example of how brutal the legal system can feel when paperwork and reality collide. You've got a defendant standing in court, convinced that a past mistake, maybe even a system error, completely derailed his life. He's talking about missed notices, lack of due process, and a chain reaction that led him straight into deeper legal trouble. But here's the twist. None of that may actually matter today. Because in this courtroom, the judge is laser-focused on one cold, hard question. What did the official record say on the exact day of the stop? Not what should have happened, not what could have happened, but what did happen on paper. And if that record says suspended, then everything else might just fall apart. So the real tension here is this. Can someone be punished for something that might have started with an error? Or does the law only care about what's officially recorded, no matter how unfair it feels? Stick around, because this judge is about to make that answer crystal clear.
Okay, I did see Mr. Blade's motion. I did have a chance to see that, read that one already, so I'm going to read the people's response. Okay, I've had a chance to review. So anything you want to add to your written brief?
Just that there was no personal jurisdiction in the court back the authority to make a judgment or default judgment.
You're talking about the Monroe case?
Yeah.
Okay, go ahead.
They lack jurisdiction in order to make that case or make a judgment for.
Anything else?
I can't find them easily to prove service and collective. I saw people service from Percival.
Just to be clear for the record, we're still talking about the Monroe case?
Yes.
Okay, go ahead. Right.
To ask for proof of service that were unable to provide it.
Right.
They told me that it was with the sheriff. So I went over to the sheriff's office to ask for the proof of service because that's their reason.
Right.
Because I never received a notice to appear in court, so I had no idea that we were charged with it again.
Okay.
And going forward, I go to the sheriff's office. I ask for the proof of service from the sheriff's secretary clerk. I'm not sure that the order position or if she's at line of test. But she noticed that the ticket had the officer's name, which happened to be down currently the defendant. He come out and spoke to me. He said, I don't remember this ticket. I don't even believe I was I don't even believe I was on that shift at this time. A few things that he mentioned to me. So I wasn't prepared for this. I was expecting everything supposed to be correct. When he spoke to me, I took what he said and I said, okay, maybe I can get him to fill out an affidavit.
Right.
The things he said, I'm not asking him for anything in my favor, just what you recall. All I want. He didn't respond in time. He mentioned that he would have no problem speaking to the court here for the last case. But I didn't receive that response in time to go to the court.
Now this is where things start getting legally interesting. The court is separating emotion from legality, and that's something a lot of people don't expect when they walk into a courtroom. The defendant is trying to connect the dots. Old case, missed notice, possible procedural errors, but the judge is narrowing the scope. Why? Because courts often operate within strict boundaries of jurisdiction and relevance. The moment the judge says, "We've got two files," he's essentially drawing a line between past grievances and the current charge. And here's the key legal concept. Even if the original suspension had issues, unless it was officially reversed or corrected, it still stands as valid in the system. That's a harsh reality. So the big question for you watching is, Should the system allow room for these kinds of backstory defenses, or is it right to focus only on what's officially recorded?
Issue with that fact? If I told you that your driving record listed you as a suspended driver on November 29, 2025, you have no argument one way or the other whether or not that's the case.
One more time.
No, that's all right. I don't want an answer if you don't understand the question. If I told you your Secretary of State driving record showed you as a suspended driver on November 25th of 25, would you have any reason to deny that as factually correct? Okay. All right. So I'm going to deny your motion for two reasons. Number one, his actions are based on what the Secretary of State says, not what the Monroe County Sheriff's Office says. B, I don't have the authority to do what you're asking me to do, because if I understand the situation, your Monroe case has been completely adjudicated in Monroe. They've left that on your record. I don't have the authority to change that record.
That's not what my motion is asking, but I'm only asking you to recognize the jurisdiction. That's all I'm asking.
I can't do anything with them. Even if I buy your argument as completely true, you're still suspended and were, on the date of this ticket, my ticket, the one I've got authority over, you were suspended by the Secretary of State. Whether or not that was a valid or invalid suspension, you were still suspended. So my ticket, the Huron Township ticket, is a perfectly valid ticket moving forward.
But the jury,
Gather your thoughts. I'm not in any hurry. These kids want a show.
default judgment issued without prior notice can be deemed as a violation of the party's right to due process.
Absolutely. Absolutely. But not by me. I can't override the Monroe Court. Now, I can take all this into consideration when I sentence you on this file, but I can't set aside what happened in Monroe. Okay. Okay. Are you just seeking to mitigate your damages here? Are you just seeking to mitigate your damages in this
right
court?
Here might be the most critical moment in the entire hearing. The judge isn't asking about feelings, fairness, or even what actually happened in Monroe County. He's asking about the record. Specifically, the Secretary of State's record. And in legal terms, that's everything. Because in cases like this, the prosecution doesn't need to prove that the suspension was fair. They only need to prove that it existed. That's a huge distinction. The defendant is trying to argue due process, that he never got proper notice, but the judge is essentially saying, that may be a problem, just not one I can fix. And that highlights a major limitation in the legal system. Courts can only act within their authority, so even if something went wrong elsewhere, it doesn't automatically erase what's on file. It's a tough pill to swallow. But what do you think? Should judges have more flexibility to consider these situations?
Well, then you got a problem, but I can't fix it. I don't have the authority to fix it. If we have a trial on today's DWLS case, as prosecutor, she's going to have to prove to me that on November 29, 2025, your driving privileges were suspended in the state of Michigan. And she's going to have to prove to me that you were driving a vehicle on that date in Huron Township. If she proves that to me, I'm finding you guilty of drove while license suspended, revoked, or denied. The fact that the Secretary of State shouldn't have suspended you does not change that at all. You were suspended. Whether or not Monroe screwed up or they didn't screw up, you were suspended. So I'm denying your motion. Okay? I'm assuming we can have some pretrial conversation.
And your
Okay.
Mr. Blake, if one wishes to plead to the drug license suspended, I will dismiss the two remaining.
And I don't even have the remaining charges, so are they already in default? Or did I just not get the files?
Vehicle and another misdemeanor registration title among the plea.
Oh, I'm sorry. I was looking for civil infraction. Okay. All right. Do you want to avail yourself of that offer? He will dismiss 2 misdemeanors if you plead to the drove while license suspended. So the misdemeanor unregistered vehicle and the plate or registration violation misdemeanor, right, those 2, would be dismissed if you plead to the drove while license suspended, revoked, or denied.
Leave that open.
The hallway is yours. Yeah, go take a minute. That's fine. Why?
Research.
You no objection to another? We'll adjourn it. Oh, I don't care. March 12th, give you enough time?
Yes.
Okay, so Heather will prepare a notice on that one. Now, as to the December 1, 2016 file, our records show that you owe $840. Are you in a position to make some kind of a payment plan on that?
But I have any money to pay. I currently don't have any money to pay.
All right, you're confused. You don't have any money today?
Yes.
All right, but you could commit to some regular payments and make them. How much, how often, when do you want to start?
I think my financial situation, but I don't make very much money.
I need you to make some kind of commitment today if you can. You don't have to start it today.
It shows that.
Okay. How much?
Even if it's just $1.
No, I'm not paying a clerk to process a dollar
And
payment.
just like that, the judge brings it all to a close with a ruling that might feel cold, but is legally consistent. The takeaway here is powerful. In the eyes of the court, official records carry more weight than personal explanations. Even if the defendant truly never received notice, even if there were mistakes in the earlier case, none of that overrides what the system showed on that specific day. The judge made it clear, this court does not have the authority to rewrite history from another jurisdiction. However, he can consider those circumstances during sentencing, which leaves a small window of leniency. This case highlights a bigger issue in the legal system, how procedural errors can snowball into life-altering consequences. So now we turn it over to you. Do you think this ruling was fair? Or should the court have taken a deeper look into the past error? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.